Question 1. A signer presents a document affecting real property title for notarization. In which of the following situations must the notary obtain the signer's right thumbprint in the journal? A. When notarizing a signature on a request for full reconveyance. B. When notarizing a signature on a homestead declaration. C. When notarizing a signature on a deed of trust. D. When notarizing a signature on a 30-day notice to quit. Answer: C. When notarizing a signature on a deed of trust. California law mandates that a notary obtain the signer's thumbprint in the journal for any notarial act involving a power of attorney, deed, quitclaim deed, or deed of trust. A deed of trust is a document that secures a loan on real estate, directly affecting the property's title, and is specifically listed in the statute requiring a thumbprint. The other documents listed, while related to property, do not fall under the category of instruments for which a thumbprint is compulsory. Remember this key group: if the document is a deed, deed of trust, or power of attorney, a thumbprint is a must. Question 2. If a notary changes their business or residence address, they must notify the Secretary of State. A. By certified mail within 30 days. B. Online or by mail within 30 days. C. By telephone within 10 business days. D. In person at the county clerk's office within 60 days. Answer: B. Online or by mail within 30 days. A notary public is responsible for keeping the Secretary of State informed of any change to their residence or business address, ensuring official correspondence can always reach them. The law specifies this notification must be made within 30 calendar days of the change and can be conveniently submitted either by mail or through the Secretary of State's online portal. Missing this 30-day deadline can result in a fine, so it's a critical administrative task. A helpful tip is to set a calendar reminder anytime you move to update your notary record, just as you would with the DMV. Question 3. A notary is asked to notarize a signature on a document written in a language they do not understand. The signer appears competent and has proper identification. The notary may: A. Notarize the signature only if the signer provides a certified English translation. B. Refuse to notarize the signature, as understanding the document is required. C. Notarize the signature if the notarial certificate is in English and the notary can communicate with the signer. D. Refer the signer to a notary who is fluent in the language of the document. Answer: C. Notarize the signature if the notarial certificate is in English and the notary can communicate with the signer. A notary's primary duty is to verify the identity of the signer and witness the signing, not to understand or validate the contents of the document itself. Therefore, a notary can proceed with a notarization for a foreign language document as long as they can communicate directly with the signer to administer the oath or take the acknowledgement. The notarial wording, or certificate, must be in a language the notary understands, typically English, so they can properly execute it. The key takeaway is that your focus is on the signer and the notarial act, not the document's text. Question 4. A person who is not a commissioned notary is found guilty of advertising as a notary public. What is the potential penalty for this offense? A. An infraction punishable by a warning. B. A misdemeanor. C. A felony if the person collected fees. D. A civil penalty payable to the Secretary of State only. Answer: B. A misdemeanor. Illegally representing oneself as a notary public is a serious violation of the law, intended to protect the public from fraud and unqualified individuals. California law classifies this act as a misdemeanor, which is a criminal offense punishable by fines and/or potential jail time. This rule applies even if the person did not perform any actual notarial acts but merely advertised themselves as being a notary. Think of the notary commission as a license to practice a specific trade. Advertising without that license is a crime. Question 5. The venue section of a notarial certificate, which typically reads, State of California, county of underscore 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 underscore, establishes. A. The county where the document will be filed. B. The county where the signer resides. C. The county where the notarial act took place. D. The county where the notary's commission is filed. Answer: C. The county where the notarial act took place. The venue establishes the geographical location where the notarization occurred, specifically the state and county where the signer personally appeared before the notary. This is a critical element because it confirms the notary was acting within their jurisdiction at the time of the service. For example, if a notarization happens in San Diego County, the venue must state, County of San Diego, regardless of where the signer lives or where the document is headed. Always remember to fill in the venue based on where you are physically standing with the signer. Question 6. A notary may not certify a copy of A. Power of attorney. B. Journal entry requested by the Secretary of State. C. Birth certificate. D. Letter from the signer's personal files. Answer: C. Birth certificate. California notaries are prohibited from certifying copies of vital records, such as birth, death, or marriage certificates, because these are publicly recordable documents. The official custodian of these records, typically a county recorder or state registrar, is the only entity authorized to issue certified copies. A notary can, however, certify a copy of a power of attorney or, upon written request, a copy of their own journal line item. A helpful way to remember this is if a government agency can issue a certified copy, a notary cannot. Question 7. A notary is presented with a document that has a pre-printed notarial certificate from another state. The certificate wording is different from California's required wording. The notary should: A. Cross out the out-of-state wording and write in the correct California wording by hand. B. Refuse to notarize the document. C. Use the out-of-state certificate as long as the document is being filed in that state. D. Complete and attach a separate, loose certificate with the correct California wording. Answer: D. Complete and attach a separate, loose certificate with the correct California wording. When notarizing a document in California, the notary must use notarial certificate wording that complies exactly with California law. If the provided certificate does not match, the notary cannot simply cross it out or alter it on the document itself. The correct procedure is to attach a separate, completed, loose certificate, containing the proper state-approved language for the act being performed, such as an acknowledgment or a jurat. Always remember that you cannot alter the original document, so attaching a correct, separate certificate is the only compliant solution. Question 8. A notary is asked to notarize her husband's signature on a grant deed for a property they own together. The notary is not named as a grantee but has a community property interest. The notary should: A. Proceed with the notarization since she is not named in the document. B. Proceed, but note her marital relationship in the journal entry. C. Refuse, as she has a direct financial interest. D. Ask another notary in her office to perform the notarization. Answer: C. Refuse, as she has a direct financial interest. A notary public is disqualified from performing a notarial act if they have a direct financial or beneficial interest in the transaction. Even if not named directly on the grant deed, a spouse's community property interest in the real estate constitutes a direct financial interest, creating a conflict. Notarizing in this situation would be improper and could invalidate the notarization and subject the notary to penalties. The safest rule is to never notarize for yourself or a spouse on any document involving finances or real property. Question 9. For which of the following notarial acts must the signer be in the physical presence of the notary? A. Proof of execution by a subscribing witness. B. Acknowledgement. C. Jurat. D. All of the above. Answer: D. All of the above. The core requirement for all traditional notarial acts in California is the personal appearance of the signer before the notary. This means the individual must be physically present at the same time and in the same place as the notary for the act to be valid, whether it's for an acknowledgement, a jurat, or a proof of execution. The concept of personal appearance is fundamental to the notary's role in verifying identity and observing the signing or sworn statement. Unless specific remote online notarization laws are in effect and followed, assume that, in my presence, always means physically face-to-face. Question 10. A notary who is not a licensed attorney advertises their services in a Spanish-language newspaper. Which of the following is a mandatory element of this advertisement? A. Listing the notary's commission expiration date in at least 10-point font. B. Stating that the notary's fees are set by the Secretary of State. C. Including the statement, I am not an attorney and cannot give legal advice about immigration or any other legal matter. D. Translating the term notary public to notario público to attract Spanish-speaking clients. Answer: C. Including the statement, I am not an attorney and cannot give legal advice about immigration or any other legal matter. State law strictly prohibits a notary who is not an attorney from using the term notario or notario público, as it falsely implies legal authority in many Latin American cultures. To prevent the unauthorized practice of law, any non-attorney notary advertising in a foreign language must include a specific disclaimer, in both English and the foreign language, stating they are not an attorney and cannot provide legal advice. For instance, an ad in Spanish must contain this notice to protect consumers from being misled. A good rule of thumb is to never use notario público and always include the I am not an attorney disclaimer in foreign language ads. Question 11. What is the main difference between an acknowledgement and a jurat? A. A jurat requires the signer to be identified by a credible witness, while an acknowledgement does not. B. For an acknowledgement, the signer must sign in the notary's presence, for a jurat, they do not. C. For a jurat, the notary must administer an oath or affirmation to the signer. D. An acknowledgement has a maximum fee of $10, while a jurat has a maximum fee of $15. Answer: C. For a jurat, the notary must administer an oath or affirmation to the signer. The critical distinction between these two common notarial acts lies in the verbal ceremony performed. For a jurat, the signer must swear or affirm that the contents of the document are true, and the notary must administer this oath. In contrast, for an acknowledgement, the signer is simply declaring that they willingly signed the document, and no oath about the document's truthfulness is required. So, if you see the words sworn to or affirmed, think jurat. If you see acknowledged, think acknowledgement. Question 12. A signer does not have an acceptable form of identification. The notary properly identifies the signer using one credible witness whom the notary personally knows. The credible witness must A. Sign the notary's journal and present a state-approved ID. B. Sign the notary's journal and take an oath or affirmation. C. Sign the document being notarized as a co-signer. D. Have known the signer for a minimum of 5 years. Answer: B. Sign the notary's journal and take an oath or affirmation. When using a single credible witness, 2 key conditions must be met: the notary must have personal knowledge of the witness's identity, and the witness must have personal knowledge of the principal signer's identity. The witness must then sign the notary's journal and be placed under an oath or affirmation, swearing to the signer's identity. This sworn statement is what legally substantiates the identification. Remember, 1 credible witness means the notary knows the witness, and 2 credible witnesses means the notary does not know them but identifies them with ID. Question 13. A notary's official seal is lost, stolen, or damaged. The notary must notify the Secretary of State. A. And the local police department within 30 days. B. By certified mail immediately. C. And the county clerk within 10 days. D. Immediately, in writing. Answer: D. immediately, in writing. A notary's official seal is a tool of public trust, and its security is paramount. If the seal is lost, misplaced, stolen, or rendered unusable, the law requires the notary to notify the Secretary of State's office immediately and in writing. This immediate notification allows the state to record the loss and helps prevent fraudulent use of the seal by unauthorized individuals. The key here is the urgency. There is no grace period, so written notification must be sent as soon as the notary becomes aware of the problem. Question 14. A notary may charge an additional fee for travel to a client's location if A. The travel fee is the standard mileage rate set by the IRS. B. The notary and signer agree upon the travel fee in advance. C. The distance is more than 10 miles from the notary's primary place of business. D. The notary informs the signer that the travel fee is required by state law. Answer: B. The notary and signer agree upon the travel fee in advance. While the fees for individual notarial acts, like a jurat or acknowledgement, are capped by law, a notary is permitted to charge a separate fee for travel. This travel fee is not regulated and is determined by the notary, but it must be disclosed to and agreed upon by the signer before the travel occurs. It's crucial that the notary does not misrepresent this fee as being mandated by the state and clearly itemizes it separately from the statutory notarization fees. Always get a clear yes on travel fees beforehand to avoid disputes. Question 15. A notary is asked to notarize a signature on an incomplete document, where blank spaces are intended to be filled in later. The notary should A. Fill in the blanks with "not applicable" before notarizing. B. Note in their journal that the document was incomplete. C. Refuse to perform the notarization until the document is complete. D. Proceed with the notarization, as they are not responsible for the document's content. Answer: C. Refuse to perform the notarization until the document is complete. Notarizing a signature on a document with blank spaces is strictly prohibited because it creates an opportunity for fraud after the fact. The notary's duty is to ensure the document is complete at the time of notarization to protect the signer and the public. If a signer presents an incomplete document, the notary must refuse the service until all spaces are either filled in or lined through by the signer. A good practice is to scan the document visually for any blanks before starting the notarization process. Question 16. What information is a notary required to record in their journal entry for an acknowledgement? A. The name of the person who requested the notarization, if not the signer. B. A description of the document, the date, the fee, the signature of the person whose signature is being notarized, and the type of notarial act. C. The signer's address and telephone number. D. The name and address of the document's recipient. Answer: B. A description of the document, the date, the fee, the signature of the person whose signature is being notarized, and the type of notarial act. California law specifies exactly what must be included in every journal entry to create a complete and reliable record of the notarial act. For an acknowledgement, this includes the date, time, and type of act, the character of the document, the signature of each signer, how the signer was identified, the fee charged, and the signer's thumbprint if required. Details like the signer's phone number or the requester's name, if different from the signer, are not mandatory components of the journal entry. Keeping your journal entries consistent and complete is a cornerstone of professional notarial practice. Question 17. A subscribing witness may be used to prove the execution of A. Grant deed. B. Mortgage agreement. C. Power of attorney. D. Quitclaim deed. Answer: B. Mortgage agreement. The notarial act of proof of execution by a subscribing witness allows a person who watched the principal signer execute the document to swear to that fact before a notary. However, California law prohibits this method for certain documents where the personal appearance of the principal signer is deemed essential, specifically for any deeds, like grant or quitclaim deeds, and powers of attorney. Therefore, This method can be used for other documents like a mortgage agreement, which is not on the prohibited list. Remember, if it's a deed or a power of attorney, proof of execution is not an option. Question 18. Upon resignation, revocation, or expiration of a notary commission without renewal, the notary's journals must be delivered to A. The Secretary of State's office in Sacramento. B. The county clerk of the county where the notary's current oath is on file. C. A professional record storage company for 7 years. D. The notary's personal attorney for safekeeping. Answer: B. The county clerk of the county where the notary's current oath is on file. Notary journals are public records that must be preserved even after a notary stops practicing. The law mandates that within 30 days of a commission ending, for any reason other than death, the notary must deliver all of their journals to the clerk of the county where their most recent oath of office is filed. This ensures the public and law enforcement can continue to access these important records. A simple way to remember this is, your oath is filed with the county clerk, so your journals go back to that same office when you're done. Question 19. A signer's driver's license expired 3 years ago, but it otherwise contains all the required elements of an acceptable ID. Can the notary accept this ID to verify the signer's identity? A. No, any expired ID is unacceptable. B. Yes, as long as the photo still resembles the signer. C. Yes, because it was issued within the last 5 years. D. No, because it has been expired for more than 2 years. Answer: C. Yes, because it was issued within the last 5 years. California law provides a specific exception for using an expired identification card to verify a signer's identity. A notary can accept an expired California driver's license or ID card as long as the card was issued within the past 5 years. The key factor is the issuance date, not the expiration date in this specific scenario. For example, if a license was issued in 2021 and expired in 2024, a notary could still accept it in 2025 because it was issued less than 5 years ago. Question 20. A notary who willfully and knowingly performs an act that is a direct cause of financial damage to another person may be liable for a civil penalty of up to A. $1,500. B. $750. C. $10,000. D. $2,500. Answer: C. $10,000. Notary misconduct that directly leads to financial harm is treated very seriously under the law. If a notary's willful action, such as knowingly notarizing a forged signature, causes someone to lose money, that notary can be held liable in a civil lawsuit for up to $10,000. This substantial penalty underscores the importance of following all notarial procedures diligently to prevent fraud and protect the public. This high penalty amount serves as a strong deterrent against intentional wrongdoing by a commissioned notary. Question 21. When a signer executes a document using a signature by mark, e.g., an X, the notary must A. Have one witness who writes the person's name next to the mark. B. Have 2 witnesses, and one of them must write the person's name next to the mark. C. Refuse the notarization, as a full signature is required. D. Have 2 witnesses who both sign the notary's journal but not the document. Answer: B. Have 2 witnesses, and one of them must write the person's name next to the mark. The procedure for a signature by mark ensures there is no doubt about the identity of the signer or the validity of their mark. The law requires 2 witnesses to be present who watch the signer make their mark. One of these witnesses must then write the signer's name next to the mark on the document, and the other witness must sign their own name on the document as a witness. Both witnesses' signatures and information must also be recorded in the notary's journal. Question 22. Which of the following statements must be included on every notarial certificate of acknowledgement completed by a California notary? A. Subscribed and sworn to, or affirmed, before me. B. Witness my hand and official seal. C. A notary public or other officer completing this certificate verifies only the identity of the individual who signed the document. D. This notarization does not validate the truthfulness of the contents of this document. Answer: C. A notary public or other officer completing this certificate verifies only the identity of the individual who signed the document. To prevent public confusion about the scope of a notarization, California mandates that a specific consumer protection notice appear on all certificates of acknowledgement. This notice clarifies that the notary's role is limited to verifying the signer's identity and does not mean the notary has approved, validated, or confirmed the truth of the document's contents. This disclaimer must be enclosed in a box and placed at the top of the certificate. It's a key feature that distinguishes a compliant California acknowledgement from others. Question 23. A notary is a paid employee at a private company and performs notarizations as part of their job duties during business hours. The fees collected for these notarizations belong to A. The notary, who must report them as personal income. B. The employer, if there is a prior written agreement to that effect. C. The Secretary of State. D. The employer, as it is always considered part of the job. Answer: B. The employer, if there is a prior written agreement to that effect. By default, the fees for notarial services belong to the notary public who performs them. However, a notary and their employer can enter into a written agreement that requires the notary to remit the fees to the employer, typically when notarizations are part of the job and performed on company time. Without such a pre-existing written agreement, the notary is entitled to keep all the fees collected. Always clarify this with an employer in writing to avoid any misunderstanding. Question 24. A peace officer suspects a notary's journal contains evidence of a crime and demands to inspect it. The notary must A. Surrender the journal immediately to the peace officer. B. Refuse, as the journal is confidential and can only be surrendered with a court order. C. Tell the officer to submit a written request to the Secretary of State. D. Allow the officer to inspect only the specific entry in question. Answer: A. Surrender the journal immediately to the peace officer. While a notary journal is a confidential document, a notary must surrender it to a peace officer who is acting in their official capacity and has probable cause to believe the journal contains evidence of a crime. The officer is not required to have a warrant or court order to demand the journal in this situation. Refusing to surrender the journal under these circumstances can result in the notary's commission being suspended or revoked. The rule is to comply with the officer's request and obtain a receipt for the surrendered journal. Question 25. The maximum fee a notary may charge for administering an oath for a deposition and issuing the certificate is A. $15 per signature. B. $30. C. $7 for the oath and $7 for the certificate. D. $10. Answer: C. $7 for the oath and $7 for the certificate. Notary fees are set by statute, and the fee schedule includes specific amounts for less common acts like depositions. For a deposition, the notary may charge a fee for administering the oath to the deponent and a separate fee for completing the certificate on the deposition transcript. The law sets these fees at $7 for the oath and $7 for the certificate, for a potential total of $14 for these two actions. Remembering that some complex acts allow for multiple, separate fees is key to charging correctly.